Hello, I'm attorney Vince Davis. With nearly 40 years of experience in California law, I'm here to discuss the essential rights and regulations every tenant in our state should know. Tenant law in California is complex and constantly evolving. Today, we'll cover evictions, security deposits, habitability, and the recent rent control laws. Let's start with the eviction process. In California, a landlord cannot simply lock you out or remove your belongings without a court order. The process must begin with a proper written notice, such as a 3-day notice to pay rent or quit, or a 30-day notice for month to month tenancies. If the tenant doesn't comply with the notice, the landlord must file an unlawful detainer lawsuit in court. You then have a limited time to respond. A judge will then hear both sides. It is critical to have legal representation to ensure your defenses, like improper service or habitability issues, are heard. Next, let's talk about security deposits. This is one of the most common areas of dispute between landlords and tenants in California. Generally, a landlord can charge up to 2 months' rent for an unfurnished unit or 3 months for a furnished one as a security deposit. Once you move out, the landlord has exactly 21 days to return your deposit in full or provide an itemized statement of deductions. Landlords cannot deduct for ordinary wear and tear. If they withhold money unfairly, you may be entitled to up to 3 times the amount in damages. Now let's discuss habitability. Every residential lease in California includes an implied warranty that the premises are fit for human occupation. This means the landlord must provide working heat, plumbing, electricity, and ensure the building is weatherproof and free of vermin. If repairs are not made after reasonable notice, tenants may have the right to repair and deduct the cost from rent, but this must be done very carefully. Withholding rent is a high-risk strategy and should only be done after consulting with an attorney to avoid being evicted for non-payment. Rent control is a major topic in California. The Tenant Protection Act of 2019, also known as AB 1482, provides statewide protections. AB 1482 caps annual rent increases at 5% plus the local inflation rate, or 10%, whichever is lower, for many units across the state. It also requires just cause for eviction after a tenant has lived in the unit for 12 months, meaning the landlord needs a specific reason to end the lease. Be aware that some properties, like newer construction or certain single-family homes, may be exempt. Local ordinances in cities like LA or SF may offer more protection. Tenants also have a right to privacy. Your landlord cannot enter your home without a valid reason and generally must provide 24 hours notice. Exceptions include emergencies like fires or floods. Outside of those, your quiet enjoyment of the property is protected by law. Landlords are prohibited from retaliating against tenants who exercise their legal rights, such as reporting a code violation or joining a tenant union. Furthermore, housing discrimination based on race, religion, gender, disability, or source of income is illegal under the Fair Employment and Housing Act. If you're in a dispute over a security deposit, documentation is your best friend. Always take photos of the unit before you move in and after you move out. You have the right to request a pre-move out inspection. This allows you to fix issues before they become deductions from your deposit. Defending an eviction often involves looking for procedural errors. If the landlord's notice was even slightly incorrect, the case may be dismissed. If you're being evicted, but the unit has serious health or safety violations, this can be a powerful defense known as a breach of the warranty of habitability. Always read your lease carefully. While California law overrides many illegal lease terms, knowing exactly what you signed is vital for any legal dispute. Late fees must be reasonable. If a late fee is excessive or acts as a penalty rather than compensation for the landlord's loss, it may be unenforceable. For deposit disputes under $12,500, small claims court is an efficient way for tenants to seek justice without a lawyer. However, for eviction cases or complex habitability issues, the stakes are much higher. You need professional legal guidance to protect your housing. The law is here to protect you, but navigating it alone can be overwhelming. An experienced attorney can identify defenses you might not even know you have. Your home is your sanctuary. Don't let a landlord's illegal actions or a confusing legal notice disrupt your peace of mind and your future. Remember, proper notice is required for eviction. Deposits must be handled fairly, and your home must be safe and habitable. You have the law on your side. And always check if your specific unit falls under local rent control or the statewide Tenant Protection Act. These laws are your strongest shield against rent hikes. If you're facing an eviction notice, a deposit dispute, or poor living conditions, don't wait. The sooner you act, the better your chances of a positive outcome. My team and I are ready to help you navigate these challenges. We have decades of experience defending the rights of California residents. Thank you for watching. Stay informed, stay protected, and remember that we are here to support you in all your tenant law matters. Call us at 888-888-6582. That's 888-888-6582. We look forward to helping you.